There are clearly going to be issues that facts that come before a judge that he or she's seen for the very first time. There's no doubt about that because there's too many different types of cases. And a lot of those facts, the judge is going to rely on the lawyers to provide those through different motions that are filed from the very beginning of the case. And that's what I was saying earlier. You have to kind of know from the very beginning of the case how the end is going to, you have to know where all the pieces are going to fit as soon as that lawsuit's filed. So there are a lot of motions that get filed very early in the case with regard to getting rid of parts of the lawsuit to kind of narrow it down for the eventual trial or eventual settlement. But a lot of the information comes from the two lawyers or however many lawyers there are in the case, and sometimes you just go and do your own research as a judge. You don't have to rely on what the lawyers feed you. As a jury would have to rely on just whatever the lawyers feed them, but a judge doesn't have to do that. So a judge just goes up there and works hard and finds the information that he needs on those particular facts if he doesn't know them.
When you, as a judge, have a scheduling conference, the first question the judge usually asks is, what is this case about? And at that point, the lawyers tell the judge in plain terms, this is what the case is about. Here are the roadblocks, here are the hiccups, and here are what we're going to have issues with. And that's where you learn what the case is about. And to me, that's a simple answer is, tell me, what is this about?
Well, I understood your question a little bit differently from them because I understood it as being, as a lawyer, how do you get the knowledge base to handle complex cases? And there's two ways. One is you can do the research, but the other is if it's a case that's a very narrow application and both factually and legally, sometimes I refer the case to another lawyer that I know has handled cases like that before. As a judge, it would be a matter of let the two lawyers present their case to me and present their legal arguments, present their facts, and then I'm going to do the best I can given those two sets of arguments and two sets of evidentiary presentations. I'm going to do the best I can to decide which one's right.
As a lawyer or a judge, you are required and have an obligation to be a student of the law and a student of the facts. If parties come before you in a complex matter that you're unfamiliar with, you have an obligation to research the law, to make sure that your rulings are correct under the law. And even if the lawyers have shortcomings, you still have an obligation to reach the right result based on the evidence presented to you.